In a dramatic turn of events, all living former chairs of the Federal Reserve, along with a notable array of ex-Treasury secretaries and former White House economic advisors, have rallied together to implore the Supreme Court to intervene and block President Donald Trump from dismissing Federal Reserve Governor Lisa Cook, while her legal challenge unfolds. On May 23, 2022, Lisa Cook took the oath of office as a Federal Reserve Board member during a ceremony at the Federal Reserve's William McChesney Martin Jr. building in Washington, D.C. This event underscored her significant role within the Federal Reserve System. A legal brief filed by these former officials passionately argues that the Federal Reserve's independence is crucial to the integrity of our national monetary framework. They stressed the necessity of this independence, which is rooted in the limited authority that Congress has granted to the Fed to achieve predefined economic goals. They articulated that allowing Trump to proceed with the dismissal of Cook while her lawsuit is pending would severely threaten this autonomy and undermine public trust in the Federal Reserve. The list of notable signatories to this brief is profound. It features distinguished former Fed chairs such as Alan Greenspan, Ben Bernanke, and Janet Yellen, in addition to former Treasury secretaries like Robert Rubin, Larry Summers, and Timothy Geithner. Moreover, a group of former chairs from the White House Council of Economic Advisors, including Glenn Hubbard and Christina Romer, also added their support, showcasing that these individuals have served under both Democratic and Republican administrations. Notably, economists Ken Rogoff, Phil Gramm, and John Cochrane added their names to the brief as well. Phil Gramm's involvement is particularly striking. He is a Republican who held a position as the chairman of the Senate Banking Committee, demonstrating a bipartisan concern for the situation at hand. The brief warns that allowing Cook's removal could open the door to political meddling within the Federal Reserve, which would ultimately damage public trust in the institution's independence and jeopardize the effectiveness and credibility of U.S. monetary policy. This urgent filing comes as Cook's legal team faces a tight deadline of 4 p.m. ET on Thursday to respond to the Justice Department's position, which asserts that Trump should have the authority to dismiss her from the 7-member Federal Reserve Board as the Supreme Court evaluates the president's legal justification for firing her. On August 25th, Trump announced his decision to terminate Cook, alleging her involvement in mortgage fraud concerning applications she submitted for 2 residential properties she owns. However, Cook firmly denies these accusations. In response to the firing, Cook has initiated a lawsuit in U.S. District Court in Washington, D.C., seeking a judicial order to prevent her dismissal. On September 9th, a judge ruled in her favor, temporarily blocking Trump from firing her as her case progressed. This ruling was subsequently upheld by a divided panel from the Federal Appeals Court in D.C. Now, Trump has appealed to the Supreme Court, asking that it reverse these lower court orders and permit him to proceed with removing Cook. As this situation evolves, it raises questions about the balance of power between the presidency and the independence of key federal institutions. How much authority should the president truly wield over positions that are meant to remain insulated from political influence? What do you think? Does the Supreme Court have a role to play in safeguarding the integrity of the Federal Reserve, or is this an overreach into presidential authority? We invite you to share your thoughts in the comments.